Hey folks, James Abrinio, and in this video, let's talk about, I think, an interesting issue, why you may want to settle your case sooner rather than later. And this title, I think, hopefully should have grabbed your attention because if you're going through a serious auto accident case here in Virginia, or maybe you're going through not such a serious one, maybe soft tissue injury, and you're making a clean recovery after a few weeks, I think this discussion still applies because I'm framing it in a way that I want you to be thinking about the value of early settlement versus going into litigation with your case. Now, as you might imagine, it's not as simple as settle your case now. It's always going to work for you. I just want you to be thinking about timing of things and the value of things in order to consider, I think, a way to look at your case that may be useful. Again, this is my view, my own personal view, how we operate here at Abrinio Law. And so you can agree or disagree. Feel free to comment below. I always love discussion, and there's no easy answer, as you're going to see. So first of all, caveat, every case is different. Every person is different, but you make the decision. What I mean by this is the facts of every case is absolutely going to be different. There are no car accidents that happen exactly the same. There are no injuries that happen exactly the same. There are no recovery that happens exactly the same. There's always some differentiation of fact about the accident itself, but also you as a person. You're a unique person. You're a human being. Your own person, and your recovery may differ wildly from somebody else's recovery, even with the relatively same injury. So let's say you have a fracture of the tibia. I've had many cases where people bounce back quickly, and I've had other cases where it's just taken a long time, and some people have had permanent disability as a result of that. So every case is different. But what I end this point with is ultimately you make the decision, and I'm going to end this video reiterating this. It is not anybody else's decision about whether or not you settle your case now or go to trial or go into litigation. It is your decision to make. If you hire an attorney, ultimately it is your decision to make. Your job, the attorney's job, is to help facilitate you seeing and evaluating your options. But ultimately, nobody can force you to trial. Ultimately, nobody can force you to settlement. You should be in a position, if you're working with an attorney, where you feel comfortable about the decision that you've made, that the numbers have been laid out to you clearly. So ultimately, you understand the decision you're making, but you're making it knowingly, involuntarily. But ultimately, it is your decision. So if you're working with us, our job is not to tell you what to do. Our job is to give you our thoughts, to educate you about your options, but ultimately, hopefully, empower you to make the best decision about your own case. Now, when I'm thinking about whether or not to settle early versus suing, I always tell people you need to think about the net value in your pocket. What is the dollar value that's going to be going in your pocket? And what do I mean by that? Well, if you settle today, there are going to be costs that are, assuming you're not in litigation. Let's assume that you're in a situation where you're early in a car accident, and let's say you recover quickly. You're getting the medical records, and you're considering whether or not to file a suit. Maybe you've not made a demand to the insurance company, or maybe your attorney hasn't even yet made a demand, or maybe they've made a demand and the offer has been made, and you're not yet in litigation, meaning you haven't filed suit. There are going to be costs involved with getting into litigation, going into court, that you need to be aware of. The way most attorneys, personal injury attorneys, work is something called a contingency fee. So litigation costs are not included in that. So the attorney will take a percentage of what you get, but you are going to be responsible for litigation costs, even if the attorney is upfronting those costs. Those costs can be significant. Depositions, filing fees, expert witnesses, doctors. Depending on where it is in litigation, we're talking a few $100s to several thousands of dollars. In complex cases, it can be tens of thousands of dollars, even more. So you need to be thinking about, if you settle now, you don't have to expend those costs. But again, it's going to be your decision to make, and you want to be running the numbers. The other thing is that people need to realize is there is value in guaranteed money now. Cash in your pocket today is worth more money than if you got that same cash a year or 2 years later, after you went through the stress of litigation, the uncertainty of litigation. Guaranteed money in your pocket has inherent value in it. So let's say you're in a situation where you may get $100,000 down the road a year and a half from now, but you could settle at $90,000 now. Again, every case is going to be different, but you need to be realizing that it's not just the raw value dollars, but there is inherent value in money now and guaranteed money now. Ultimately, whether or not you think you'd rather wait for the potential of $100,000 versus settling for $90,000 in this hypothetical now, again, that's going to be your own personal decision where your attorney is going to have to help you know your options, and you may be more risk tolerant. You have to know yourself too and understand your risk tolerance. Now, the next point is there is always uncertainty at trial. Things can always go wrong at trial. Doctors can disappear. Evidence cannot be received well from a jury. You can get a judge that messes things up. So we as attorneys and attorneys like me that actually try cases, we're constantly thinking about what's going to happen in court, what's going to happen in front of the jury, what excitement we have. Because if you're a good trial attorney, you're excited about trying cases, you're interested in trying cases. This is what we do, but there is always uncertainty in trial. So things can happen. Juries can get things wrong. Judges can get things wrong. Evidence can not be admitted when it should have been admitted. Doctors could say that they're committed and then they not show up to court, and then you've got to refile it and things like that. So there's always uncertainty trial that you need to be factoring in as well. And there's the inherent stress of trying a case. I've been doing this for 15 years now, and before every trial, I still get nervous, and I'm in court a lot. You as the injured victim, you've already been through a lot. The thought of going to trial, you have to realize that it is going to be a stressful aspect. Now, some people deal with it well, and that's great. And some people need their day in court as well. So if that is value to you, and maybe I didn't articulate that well in this bullet point, but if there's value in you getting your day in court, that's also something you need to be thinking about. But just realize that going to trial is not an easy thing. It's not a cakewalk. It's not like the movies, and you got to prepare. If we're working with you, we're going to make you do trial prep and all those things, and it takes time. And we're going to be asking you a ton of questions, and you're going to have to take time off of work for the actual trial. Just be aware of that. Now, next thing you need to think about, and sorry, my PowerPoint didn't transition well, but here are the next 4 bullet points, but follow as we go. In Virginia, there's always a possibility of an appeal. So let's say you get a jury verdict and you're happy with it. Well, Virginia's just expanded its court of appeals. So now the defense gets an appeal as of right. So they're always going to get their appeal if they need it. Now, there's certain things they've got to do, like essentially put up the value of the judgment to get to the appeal, to perfect that appeal. But there's always a possibility of an appeal, and that takes time. It takes efforts. If you're working with an attorney, a lot of times the attorney's fees will go up. You have to deal with an appeal, so you have to be aware of that. And as I said earlier, you need to be thinking about the net value in your pocket. A lot of times what I'll do, and I've got a complicated case and there's a lot of numbers to be considered, I will literally, for my client, create an Excel spreadsheet. And I'll lay out, here is what my attorney's fees is, here's the litigation costs, and here's the phase of trial. And if we get to this point, this is where my attorney's fees are going to go. This is where my litigation costs are going to go. This is where, your health insurance liens and all those are going to go. And here's the actual net value in your pocket. If it was today versus settled 6 months before trial versus 3 months before trial versus at trial and all those. So you want to be looking at the net value. I always tell people, unfortunately, you have to look in a lot of ways. Your personal injury case is an asset. You have to look at it in the return on investment, that asset, because we can't make you feel better. We can't take away your pain. We can't heal you. Now, again, there is, in a lot of ways, restorative process in having your case heard by a jury, but in a lot of ways, the stress of that is counterbalanced by that. So again, that's going to be a personal decision you need to make, but you need to be looking at net value in your pocket. So if you're working with an attorney, you need to be talking about them. Well, what do you expect me to actually get if I settle now versus if we go to trial? Most attorneys will give you that estimate. Now, to be clear, even I can't give you specifics like the exact dollar amount, but we will be able to give you rough estimates of what we're talking about. So you need to be thinking about the net value in your pocket. Now, no matter what, I always tell people, if you're working with an attorney or if you're considering settling your own case, you need to be considering what will happen at trial. You need to be prepared to try your case. I want to be clear. The way that we get good settlements here in Virginia, the way that our practice works is As soon as you step in the door, we're considering your case is going to trial. We're acting as if your case is going to trial. So when we're asking you for documents, when we're asking you to do deposition prep, and we're asking you to walk through scenarios with us, we're asking for you to for us to talk about getting your doctors involved. The way that we get good settlements is we demonstrate that we've got our house in order, that we've got our ducks in a row, that we're ready to try your case. And I think that speaks volumes to adjusters when they're considering what to do with your case, whether or not they should give you more money when they're negotiating. And it's always a fail-safe. If it turns out that the case doesn't settle, you're ready to go to trial. So you need to behave as if your case is going to trial. And remember, the last point is, and I just want to reiterate this, it's always your choice. It is your choice whether or not to settle. You give your attorney authority to negotiate on your behalf. They're not allowed to go and say, well, I think the case is worth what, X, Y, and Z, so I'm going to go ahead and try to negotiate this without your involvement. You should be intimately involved with negotiations. Your attorney should be communicating counter offers and things to consider. A lot of times, again, for me and Abrinio Law, this is an iterative process. So as an offer comes in the door, we're going back to that net value spreadsheet where I'm saying, okay, here's what we're looking at. Here's the numbers. And as we're walking through that, I'm educating them. Oh, here are the issues that may come up at trial. Here's the concerns I have. Okay, this doctor is doing this and all the like. So ultimately, though, my job and my goal is to empower you, the client, to make the decision for yourself. And that goes back to the bullet point above, always be prepared to try the case. My position is, as a trial attorney, is we're always prepared to try your case. We don't depend on or assume cases are going to settle. So if you'd say to me, James, you know what? I think we're close, but I'm just not ready to pull the trigger on a settlement. I want to go to trial. Then we're ready to walk into court. And look, sometimes cases settle on the courthouse steps. That's absolutely true. But we never want to be in a position where we're left flat-footed because we haven't properly prepared. So when we're making you go through deposition preps and the like, then that's for your benefit. We don't do this for our health. We do this because we want to be prepared to make a great presentation to the court, a great presentation to the jury. So look, I hope this information is useful. And again, it's not as simple as settle your case now. Every case is different. And the point of this was hopefully to hook people in so they're looking at this and really thinking the process through. And you may have watched this video wanting to justify to yourself to just get the case done. You may be representing yourself and you just want to move on with your life. I want to be clear, there are downsides to settling your case sooner rather than later. For instance, if you've got an ongoing injury and you've got permanency and you've got treatment that you may have to have later on, if you settle now, there's no money later on. You can't go back. There's also health insurance liens and other complex issues that you need to be considering. If you're working with an attorney, you should be working through those issues and knowing those numbers. So don't just jump the gun and settle. The point of this video was really for you to think through the process and ultimately what is the net value to you dollar-wise, but also from a emotional standpoint. If there is value for you to just have your jury hear your case. If you say to me, James, I'd rather a jury give us less money and I get to tell my story, of course, we'll make that decision together. But I understand that. And if we agree that's the best decision, then that's what we'll do. If we're representing you, we don't force people to trial. We don't force them to settlement. Our view is we're essentially your GPS. We lay out the roadmap for you, and then we get you to the destination that you want to go. But ultimately, you're the one who has to type in that destination. So hopefully that this information is useful. Here's our information: website, email address, social media. Feel free to reach out to us if you have questions. If you do have other questions, comments, make sure to subscribe to this channel. We're trying to update information to give people as much useful information as possible. And follow us on social media, comment below. You may agree or disagree with this video. Feel free. We like to mix it up. We like to get input. Maybe you have an idea for other videos for us to shoot and you have questions you want answered. Feel free to let us know. We wish you the best. Until then, take care.